presentation. We're really excited to be part of GiGi's. Nancy has brought this education to the families so that we have an opportunity to be able to have regular conversations to help get everybody kind of acclimated to their level of understanding that's required for them to be able to prepare. I am Lamar B. Butler. I will host this conversation, and we will have about a few minutes just to be able to walk through some key details early on, and then go into some of the legal elements that are really important as well. For any questions, there is going to be a survey from the seminar at the back end. If you need to have a conversation, here's all the contact information for us to be able to be a part of your financial discussion. Do not hesitate to look at our website, as well as shoot us an email or phone call with any questions as we go. Jonathan David Herbie is also a part of this conversation, and he will be available as well, just as I am, and his contact information will be available to you post his segment of the discussion. First things we want to take a look at is just the baseline time frame, the timeline of children coming from stage 1 to stage 4. And what stage 1 is generally from birth to age 3, where we get early diagnosis and being able to start to get an understanding of what that lifestyle change may be required. Stages 2, we look at children that are going to be going through a very normal, happy, and long sustainable life through education in their IEP process. Obviously, this is a people-first approach, and everybody's situation will be vastly different than somebody else's. That's why the focus will always be on our loved ones, our children, and making sure that those details are specifically tailored to the needs of the child as their process goes throughout. Stage 3 is a little bit of a different standpoint, but part of the IEP is being able to have an opportunity to create a level of independence for your child. As they get to the age of graduating from high school and looking for opportunities in the workforce, as well as looking for opportunities to function as peers through having their own residence, having the capability to earn money and create wages so that they can sustain their own life. These areas are a space right now where there's a lot of legislative changes to create more opportunities for the demographic of children with needs so that they can have an opportunity of self-sufficiency. A key thing to make sure that we point out is that at some point as our parents, our caregivers, there's going to be a point at retirement that you're at a diminished capacity. You will not be able to maintain the hands-on cares for your child as much as possible. Your child will live a long, sustainable life, and most times your child will outlive you. And that's where the long back end is really important to get a handle on, so that the assets that are required, the needs that are required for the care that is needed can be maintained long into to the child's death. So we see here, just between a special needs planning timeline as well as a traditional planning timeline, there are some definitive discrepancies on how the preparation needs to be addressed for transition points along the spectrum. When we take a side-by-side look at traditional planning versus special needs planning, generally we start to look at, oftentimes we start to accumulate some assets, prepare for the educational needs for a child, as well as planning for them to launch post-graduation, possibly be a part of helping them purchase their first home. And then we start to reduce our responsibility of support for our children, and then we focus on ourselves at retirement and the distribution of wealth back into our own lifestyle as we look to have the best back end of years that we can provide. When you look at a strategy plan for a special needs family, there's a few differences in that. We want to make sure that not only are we preparing for the emergencies and the needs of right now and the consistent care of today, that care is going to be maintained long term. We want to make sure that we do keep cash reserves, we do keep liquidity available. We want to make sure that we have our legal documentation available, so that we know that the care that the child is receiving now is care that the child will be able to receive through the duration of life. As we said before, the likelihood of our child outliving us is much higher than they may think of up front. A couple of key things to take a look at. We know that about 20% of Americans are disabled or will be disabled. We also know that fewer disabilities are life-threatening at this point. From there, we look at knowing that our children will outlive parents, being in this situation, we want to take a look at what that financially requires for us. On average, a child with no special need consideration will be just about $250,000 to be able to have a substantial life. And that includes regular care, education needs, and so forth. When you look at the cost of care for a child that has autism, we have a staggering $1.4 million on average to provide the appropriate care long term for that child. For a child that has an intellectual disability, we have a substantial growth of about $2.4 million to be able to provide the care and lifestyle needs long term for a child in that space. Regardless, where we are right now in the process, this isn't something that we have to panic about. It's something that we have to evaluate, and definitely something that we want to take action on sooner than later. Many times people get so worried and nervous and panic, but realistically, it's just a matter of time to get a little bit better prepared. And from that standpoint, this is where having a conversation of your current circumstance is more appropriate. When we look at some of the potential costs associated to our long-term expenses, the list is pretty elaborate. This is not restricted to. You know that there's whatever your child's needs are, we're going to have education, we're going to have transportation possibly, whatever in-home care may be needed, therapy. The list may go on. Also, assistive technology is something that's very important, as GiGi is involved in something with Microsoft right now that is developing some technology to help for the communication pieces for a lot of the children as part of their learning tools. One thing I think people often overlook is that there is a potential for lost earnings. When your focus is so internal into the home, that can draw you away from work. You may miss more days. You may have to take a few times off that you weren't expecting. So that already affects the ability to provide for the substantial needs that would be required for a family. We've had several conversations with families that have looked at taking some of the assets that they've already accumulated, for example, retirement assets. The challenge in that is that there are distribution and tax issues that could affect the actual dollars available for a family to be able to use those as a substantial portion of care needs for long term. We look at our property. Well, oftentimes we want to make sure that our property is maintained for our children to be able to live in from a familiarity standpoint. But if we ever needed to sell that, that's not always the easiest thing to do. It's difficult to sell on a quick basis, but as well, values change on homes. And depending on where your needs may come, we may not get value that would be appropriate as well. Lastly, we look at securities, stocks, bonds, and those things. Again, we have a taxable issue as well as the values and fluctuations depending on where the market may be at the time you actually need those dollars. So these are great pieces to think about, but we also have to offset that and understand the consequences if those are our primary choices. We always suggest that you have the proper team associated to you. You should have a great attorney, an accountant, as well as a financial professional, all working together to make sure that every need is met and every need is able to be sustainable. By doing this, this will give you the best opportunity to make sure that you have prepared effectively for your family. When we look at our process, it's pretty much 4 steps. The first step is to analyze through a discovery conversation, get an understanding of where your circumstances are right now, so that we can do a best job of recommending and creating some suitable suggestions to allow you to get on the proper path of financial security long term. From there, we want to talk about how we would implement those strategies and put those things to work for you immediately, so that we can now have a level of peace and a level of comfort moving forward, knowing that those things have been addressed. And lastly, we want to make sure that as circumstances will continuously change, that we have an opportunity to review and update on a regular basis to make sure that we're always in accordance with our original goal and our original plan, even though there are going to be some deviations along the path. Hopefully that was a great start for many of the people that are in this conversation to get an understanding of what things may be for them. We were going to have more of these discussions, but right now I'd like to transition the conversation over to Jonathan Herpy to be able to walk through some of the legal discussion to be able to better understand what trust and all the legal documentation that he will go through really mean to the family. So at this point, I'm going to share this screen with Jonathan, and Jonathan will take it from here.
All right. let's see. Are you hearing that feedback, Lamar?
No, I'm not hearing anything now.
Oh, you're not hearing anything? Okay. Well, thank you for giving me the floor. You failed in two aspects. One, you required an attorney to do something techie, like create a slideshow, which is you never want to do. And you gave an attorney the floor and enabled him to talk probably for really as long as I want, and we can be very verbose at times. So
you can have as long as you like.
Exactly, yeah. Well, I would say buckle up. So, we really appreciate the opportunity to come on and be a part of GiGi's in any way possible. It's it's an honor to be associated in any way with this organization, and we really appreciate everything that Lamar is doing for the organization and inviting us to come on. Whenever I'm sitting down with a client of any kind, and I've had the opportunity and the pleasure of representing clients from all walks of life throughout my career, one of the things we always want to instill in our clients is that, like GiGi's Playhouse, and that it's a family of individuals that provide support. Our office at HDC, and me personally as an attorney, I like to have my clients feel like they're becoming part of a family in joining our firm, so that we can work together to achieve some of these goals that people have set out for themselves. And just the goals may be goals, but attaining those goals is part of why I'm here and what I what my mission is to be a part of. And especially when you're dealing with a situation, special needs child, or you're putting forth goals that you may not know how to achieve. And so I take great joy in providing my clients a level of hope and a level of security, knowing that we're a part of their team. Lamar and his group is a part of their team, and we're all going to help guide you and your children and your family through what can be a very, very confusing and troubling time. So anyway, that's my intro into what can be a very boring topic, but I hope to make it fun. Estate planning. I'm going to bifurcate this speech, I guess you'd say, into two pieces. One, traditional estate planning, associated with all walks of life, something that I've done for years and years and years, and then the other piece of it being specifically special needs planning. And there's a lot of overlap, and you're going to see that in our slides, and you're going to see that in any kind of planning, because in any kind of traditional planning, you have to plan for things that might be unexpected. So one of the things that Lamar brought up were the costs associated with raising and caring for a special needs child. I mean, one of the figures that I didn't realize: $1.4 million, $2.4 million. And when a lot of parents see these figures, the minute they see the figures, they say, "Oh my God!" First of all, the government's not going to give me that amount of money. They're not going to give me $1.4 million to enable us to do this. I'm going to have to come up with myself. And at the same time, I want to be able to provide my children while I'm alive and after I'm gone. How am I going to save that money and see that the government just doesn't take it? So I can't tell you how many families I've counseled. When they come in, they say, "Well, I can't do anything. I can't do anything because I'll lose my benefits to SSI and SSDI or Medicaid or Medicare. I can't do anything." And again, we're able to provide families with some hope in making them understand that yes, there are options. You can attain wealth. You can be wealthy. You can and you can set up trust structures that make for a very comfortable childhood, adolescence, and adulthood for your special needs child and for your family. So that's enough. I told you, Jim, lawyers, you give them the floor. It's ridiculous. So I'm going to start. So the first issue here is, what is an estate? An estate is pretty much everything you have. One of the things that I tell my clients is an estate is everything from the pencil that's on your desk to the house over your head. And whereas everything will go into an estate plan, there are different ways in which one can incorporate an IRA, insurance policies, jewelry, pencils and paper, and a house into the estate plan. It's not your problem to understand how to do that. It's my problem. But I just want to give you a definition of an estate is everything around you. So really, why do we do estate planning? Now, there are three different reasons why we do estate planning. One is to deal with issues during one's life, after one is gone, and during any kind of incapacity. And there's different vehicles and trusts and mechanisms to deal with each one of these issues. So during one's life, one of the key issues that we see is to control spending, transfers, investments. So if you are looking to segregate various investments for specific purposes, then possibly putting them into different vehicles or putting them into different trusts, it can not only be a benefit in terms of taxation, but it also can be a planning mechanism so that they mature and appreciate at different levels or at different rates and pay out to different beneficiaries. Another reason why people establish estate plans during their life, well, they have to establish during their life, but as they use them during their life, is privacy. So especially, we're seeing a lot of individuals come into our offices these days and say, you know what, I Googled my name and my address came up. Or, you know, I own a business and all of my information is on the web. Well, transferring your interest into a land trust in Illinois or a trust structure around the nation can prevent some of these privacy leaks. And what we like to see is that individuals transfer a lot of their assets, all of their assets, into a trust structure. So at the end of the day, their assets aren't as easily or readily available to individuals who are looking to find out more information about. The biggest concern people have is what happens when I'm gone. And this deals on both sides. As I told you, I'm going to bifurcate this conversation, but this is one of the overlaps. So in this case, after death, controlling who receives these assets is the primary concern and kind of is the primary topic over all these issues. We want to make sure that after an individual is gone, after a parent is gone, that assets go to the child or go to the individual who needs them most, or who is made the beneficiary. Also, believe it or not, I'm going to argue against myself and tell you that you need to pay the least amount of legal fees possible. So setting up an estate planning is actually far less expensive than not setting up an estate plan in the long run. So if you, and I'll talk about this later in terms of probate, but setting up a plan now that allocates property after death will bypass probate completely and will alleviate any expenses that are associated with probate, which it can run into the tens of thousands of dollars very quickly. And finally, incapacity. One of the things that we can never really plan for as accurately as we'd like is what happens if I am just all of a sudden incapacitated. How do we control the assets? Who's controlling the assets? And who's making medical decisions? Who's doing all these kind of things? So we want to be able to plan for that. And that is all encompassed in estate planning. So who needs an estate plan? This is always, it's funny, we have new parents and, young kids, I say they're young kids, but 30-year-old kids come in here and say, you know what, I have two kids. One of them is special needs. One of them is not. We don't have that much money and we're saving every penny we can get. We don't need an estate plan. And we have elderly individuals who come in and say, oh yeah, I don't really have that much money either. And we're just leaving it. Everybody needs an estate plan. I'm just saying, everybody needs an estate plan. And the reason why is because you want the security of benefiting your children, not only now, but after you're gone or during your incapacity. And that goes for individuals who are young and have children with special needs, or individuals who are elderly and have a different situation. So now I'm going to give you some, this is me trying to make estate planning not boring. So these are different, and this is going to be a handout so you can kind of look through the numbers a little bit more. But this definitely illustrates my point earlier, where we were talking about the costs of probate and costs of not having a trust structure. So in this case, we'll take Elvis Presley. There's nobody in the world that doesn't love his music. So He had a gross estate at the time of his death of a little bit over $10 million. His debts were almost $4 million. His attorney, God bless him, took $1.9 million, and the estate tax is $3.3 million. Now, I'll talk a little bit later about the estate taxes and how that, this day and age, that probably wouldn't occur. But at the end of the day, the guy started out with $10 million, and because he didn't have a trust structure, he didn't have an estate plan set up, he ended up with under $1 million. So you can see there's a perfect illustration of just where the process, the state and government-led process, just sucks the money right out. So this is it. Well, we're going to go. Oh, there we go. So Groucho Marx is another one. He did not have any kind of medical power of attorney, and he was declared incompetent by the court. And the court, and we'll go over this a little bit later as well, the court will appoint basically the most convenient person for the court to appoint. And that usually means some attorney that you don't know and may only have a more objective outlook on what your care may be, and really not have any subjective view or emotional stance on how everything needs to be done. So in this case, Groucho Marx lost control of fairly everything: assets, personal decisions, privacy, and costs. So here's an issue of where an individual lost, a lot in licensing fees. This is an individual, James Dean. I'm sure a lot of you know. At age 29, he died without a will. So his entire estate, including licensing fees, passed to his father, who he didn't even know, but it was appointed by the court. They basically just, as a matter of convenience, just went to the next person. And I promise I only have 2 of these, but I'm trying to keep you awake. The unintended heirs provision or the unintended heirs example is always attributed to Marilyn Monroe. So unintended heirs, what ended up happening is that 75% of her entire estate went to her acting coach, who she had wanted all of her estate assets to be donated to charity. Well, the guy who she had not written down who the intended heirs were going to be, he later married, and after his death, it went to his widow, and then she never gave it away to charity, and she just used it all. So that's an issue of her not being able to accurately convey what she wanted to happen, which would have been alleviated by some sort of trust structure. So this one's specific to spendthrifting, and this kind of gets to the point of during your lifetime, if you are incapacitated or if you pass while your children are either in a special needs situation or they are in a state of minority, what will happen is in the event they don't have any kind of estate structure, they're going to be given a lot of money very, very quickly. And in the case of a special needs child, a lot of the money could be allocated directly to the government, or there could be guardians appointed by the court that spend it frivolously or do not adequately care for the child or their best wishes. So in this case, this is just a fun, not so fun story of the Woolworth family. So the granddaughter of the Woolworth founder, she at age 10 inherited $25 million. It sounds fantastic, and there's a movie called Blank Check that sounds kind of like that. But so the trust, which had $25 million at age 10, she was given access to the entire thing because a trust structure and an estate plan wasn't set up to allocate and spendthrift for her or allocate different sums of money at different ages so she didn't go broke. So the trust ended when she was 21. Essentially, over the course of the rest of her life, she had a ton of husbands, and when she died, she hadn't invested any of it. Now there's $3,000. So, you want to kind of be the guiding light for your child, not only during their life, but after your passing. And you want to continue, more than anything, the parents are always going to care for their children more than anybody else in the entire world. I have 3 children. I know that for a fact. So you always want to have their best interests in mind and make sure that whoever you're appointing or whoever is conducting your estate planning is doing the same. So common estate plans. and I'll give you the pros and cons of each in a bit. But what we're talking about here is normally what you hear about is a last will and testament, joint ownership, meaning when you're taking a property, if you purchase a property in joint tenancy or tenancy by the entirety. Beneficiary transfers is not utilized so much anymore. And then the primary one that we're going to be talking about is revocable living trust. So a will, here's what I'll say about a will. A will is a great mechanism in supplement to a trust. But if you just have a will, here's essentially what you're going to be facing. You will go to probate. A will is a directive that is utilized by the court so that the court can simply rule in a certain way. It is basically a note given to a judge after an individual's death that says, here's how I would have done it if I were alive. Now, understand that you're in court. You have to be in front of a judge. So you have basically bypassed the reason for estate planning, and now you're in court and incurring a lot of costs. So it allows you to control some titles and pass on things to your children and pass on things to intended beneficiaries, but it doesn't really achieve the goals, all of the goals that we're looking to achieve. So what is probate? Probate, first of all, that picture on the right side should convince you that you never want to be there. That guy looks like he has absolutely no idea where he is, and the guy on the right is just a traditional lawyer. So those individuals, they don't have your best interest in mind. So it's a legal process. The will is validated by the judge. The debts are paid, and the assets are distributed according to the will. So it essentially goes line by line and says, this is exactly what the individual would have wanted. And a lot of times the court is going to appoint a guardian to make sure that everything is done according to plan. The issue is costs. Everything when you enter a courtroom, start ringing the bell because it's a lot of costs. So it's the only way to really change title after one's death in the event that there's only will, and that becomes troubling, and I'll go more into that a little bit later. So the probate illustration here is what you can see is all your stuff, your checking account, investments, heirlooms, bonds, and everything, your pencils and everything I talked about earlier, go into probate, are then distributed to everybody who basically has their hand out. So attorneys, in a lot of cases, there are probate attorneys who effectuate a lot of the intricacies of probate. There's taxes, and then it'll finally trickle down to the heirs. There's no privacy. So one of the first things that occurs is your will is filed with the court in a public sphere. So one of the fun things to do is to go online and Google celebrity wills. I mean, it's fun for attorneys, maybe not for you. But we go online, we Google celebrity wills, and everything's there. You can see everything and all of the distributions that Marilyn Monroe made, and any of the celebrities that die. You can see everything because it's all public, and that's not something that we encourage our clients to do. We think it's nobody should be involved in the distribution of your assets except for you. So again, a will is really not going to be any kind of help. It's expensive, it's time consuming, it's public, and it doesn't replace probate. So I'm just listing off these things because I'm going over them again, and I can't stress it enough. A will is only going to really get you 10% of the way there. A lot of times wills come with durable powers of attorney, which is something that is inherent in the estate plan. It's very important. So when you have a will, and I went into this a little bit earlier, when you have a will and you have minor children, and special needs children that need constant aid, the court is going to appoint a guardian. You don't know that guardian. You can't control that guardian anymore. That guardian has other children and deals with his own kids, and his interests in your child are absolutely not the same as yours. And this is not to say I'm not trying to disparage any guardians that are out there. They do, a lot of them do great work, but they don't know your child and do not have the interest for your child that you would have. And so that is one thing that everybody kind of looks at and says, good Lord, I don't want that to happen. The court controls the finances. So that means the government is controlling your finances. So if anybody on this recording wants the government to control their finances, I would say just log off right now, because there's nobody has any interest in the government controlling their finances, and that's what happens in probate.
Right.
So the child inherits everything in the legal age. So essentially what that means is the minute that child turns 18 years old, they get everything. They get everything. I know at 18, first of all, I'm pretty sure I overdrew my account regularly when I was 18, but I sure as hell could not, hold a bank account of tens of thousands of dollars or $1,000 or anything like that. But if you go through probate and just have a will, that's what's going to happen. And your 18-year-old child is going to just get one lump sum. So joint ownership is something that does pass property. A lot of times people will have joint tenancy with right of survivorship. If you look on the deed to your house, a lot of times you'll see joint tenancy with right of survivorship. What that means is essentially if one of the parents pass, the other parent title of the home will vest wholly in the other individual without going through probate or any of these kind of things. Again, it kind of gives you another 10% of the way there. So now a will gets 10%, this gets you another 10%, so now we're 20%. It effectuates some of the wishes. At least the house is transferring. But at the end of the day, we want to be able to plan for when both parents are gone, and we're dealing with children with needs that need to be met, and beneficiaries that need property to immediately be transferred and funds to be immediately transferred to help them out every day. So this is a joint ownership, a little bit of joint ownership summary. Some of these things that I put in here, I realize that not only am I going kind of fast, but this is a lot of heady stuff. So when I'm talking about it, you're listening to an attorney and you're saying, "Oh my God, this is way too much stuff to take in." What I will say, and I'll reiterate again and again, is this is my realm of competence. I know what I'm doing. Lamar knows what he's doing in his sphere, and we're going to become a member of your team to help you understand this better. So understand that you're not supposed to understand all of this today. We're here to help you in that. So beneficiary transfers is something that was utilized a lot in the past. This is where essentially the name associated with a piece of property is transferred during an individual's life to possibly a minor. One of the techniques that's used by what I would say hack attorneys is especially in the special needs sphere, is to actually disinherit the child. And I'll say it again because it's a little bit crazy. One of the techniques that's utilized by some attorneys, which they feel is a good technique, is to disinherit the child. I specifically denounce this technique. If anything, you need to take more time for your child and understand the needs and plan for the needs of the child. And professionals need to do that more than anybody. So here we are. We're going to talk about revocable living trusts right now and keeping control of all your property and your wishes with a revocable living trust. And I hope you all appreciate the 80s pictures that exist on this slide right here. So I'm going through the benefits here of a will versus a revocable living trust. So both have been used time and again throughout centuries. A lot of people think that revocable living trusts or revocable trusts or trusts, however you want to call them, have been around just a couple of years. I don't know. This has been around for a very long time. Both name someone to handle the final affairs. So both name a trustee in the case of a living trust and an executor in the case of a will. Both name who are going to receive assets. Of course, in the case of a will, the individual who's actually stamping who's going to receive the assets is a judge, whereas a trust is someone else. Avoids probate. So this is the big one. A will 100% does not do that. There should be a no right there. It does not avoid probate. And this is a huge misconception. I can't tell you how many people come into my office and say, "Well, I have a will. I avoided probate." False. Did not avoid probate. avoids living probate. Again, this associates with incapacity. So a will actually has no real effect during your life. A durable power of attorney does, healthcare power of attorney does, a will does not. A revocable living trust, the moment you put pen to paper on a revocable living trust, it becomes another person, another living person. And you can add things to that person, you can fund to that person, something we'll get into in just a bit. And you're able to give property to that thing, that trust, in order to effectuate your wishes and aid your beneficiaries during your life and after your life. So let's talk a little bit about funding your living trust. In a minute, we're going to go over, in the special needs trust realm as well as this in just a moment. But you can set up all this paperwork and go through the expense, time, and energy of setting up an entire trust structure. And at the end of the day, if you put your pen to paper and you sign that trust and then put it in a drawer and never do anything with it again, it's not worth anything. You have to fund your living trust. So what does that mean? That means retitling assets in the name of the living trust or associating an existing instrument. So for instance, insurance. An insurance product is routinely used to fund a living trust. Providing that insurance is the beneficiary of the living trust or made in the name of the living trust, you have to fund the living trust or at least give it an asset. So it's all, what I always associate it with is a living trust is a living person. It's another person that you just created that is going to hold all your stuff. Well, now in order to turn that person on or make that person living, you have to give it something. So in this case, one of the primary instruments that is utilized in order to make that trust living is an insurance product. Why? Well, one of the reasons why you provide an insurance product as the primary funding mechanism is because it's easily transferable after your death. It's a lot easier. That and cash are the most easily transferable after death. So here's a side-by-side analysis. So essentially, if you have a living trust, there's nothing to probate at all. So there's nothing to probate. There's no probate fees. Your heirs are taken care of by your trust, and there are no taxes associated with your estate, especially now because there's relatively no estate tax. There is for a joint couple, I believe it's a little bit over $22 million. In the case of a living trust, everything is owned by your living trust. It goes directly to your beneficiaries upon your death. So the very second that you pass, or the very second that you become incapacitated after an assertion that you are incapacitated, title and ownership to those products go directly to your beneficiary without any government involvement or any court involvement at all. Again, you keep control. I always tell my clients if you put things in a trust, it's actually easier to buy and sell things. One of the easiest ways you call up your attorney and say, listen, I want to buy and sell this. And I know how to, our office and between all the attorneys that will be helping you, buying and selling assets in a trust is actually incredibly easy. So you can cancel or you can change your trust at any time. Now, what I'll say about this point I made is there are two different kinds of trusts that you're always going to hear about. You're going to hear about a revocable trust and an irrevocable trust. I'm not going to go into the differences right now, but at the end of the day, there are various provisions. There are revocable trusts wherein you can change it and cancel any time. Irrevocable trusts, there's some provisions that you can and can't, and there's some differences. So the trust contains your instructions. So it literally says what you want to happen. It is a long document, whereas wills are usually very short, let's say 4 to 5 pages, maybe 10 pages. A trust can be up to 70, 80, 90 pages long. And it literally spells out everything, how you want your beneficiaries to receive, how you want your children to be cared for, how you want your assets distributed, where and when they're going to be distributed. So there's a lot of names that you're going to hear. One is the grantor, trustee, beneficiary. So I like to just go through this pretty quickly and just say the grantor is the individual that creates and controls the trust. You come into my office, you're the parents, you tell me I want to create a trust, you're the grantors. Now during your life in a revocable trust, you are going to manage the trust. Therefore, you're the trustee. So you're both the grantor and the trustee during your life. One of the biggest issues that exists and that I have been very staunch advocate for in the special needs field is establishing a solid list of successor trustees. So everybody is going to pass at some point, and we want to make sure that the individuals who are stepping into our place have the best interests of the child in mind, have the best interests of your assets in mind, and all your beneficiaries in mind. But things can happen to those individuals and so on down the line. So I like to usually have at least 2, if not 3, if not 4 successor trustees. And then, of course, at the end is the beneficiaries. So these are the individuals that receive assets when you die. So this can be anything from an individual, it can be a trust, it can be another trust, it can be a charity. Believe it or not, one of the beneficiaries that's becoming very popular is a canine trust. A lot of people love to leave a lot of assets to their dog. I'm pausing for laughter. So this gets into just controlling your inheritance. So one of the issues that always comes up and is of utmost importance is making sure that your inheritance is utilized in the fashion that is in the best interest of your child. And this is especially important for individuals. We also, in terms of how it's utilized in the special needs community, though, need to make sure that those assets are titled properly and distributed to the correct trusts necessary to avoid governmental influence, and plan for issues such as SSI, SSDI, and Medicaid and Medicare holdbacks, and to prevent individuals from losing their coverages, disability coverages, and their benefits. So these are things that are all encapsulated within a trust and are inherent in any kind of good estate plan. Minors. So when a minor is, God forbid, an individual dies and they have, or a couple dies and they have minor children, we want to make sure that there are special provisions necessary to make sure that the children don't get all of the income immediately. Again, I usually, and I always have, I can't tell you how many clients just say, well, listen, we don't really know how to properly do this. Do you have any suggestions? Absolutely. It is a free-flowing conversation with my clients as to how they would like their children to get money, when, how, at what intervals and in what amounts. And I love having those conversations because it's fun to think about the child growing up and being able to utilize this money in the way the parents want. Again, there are some provisions that enable a couple to protect from creditors, and the predators aspect goes more towards the privacy element. So, living trust summary, it avoids probate at death. It prevents court control of assets and incapacity. My career has spanned years, and the last thing that you want to do is to put the court in control of your assets during your incapacity. Provides maximum privacy, so your assets aren't just out there free flowing for anybody to see. And it allows quick distribution of assets to beneficiaries. It allows quick distribution of assets that you want to go to your beneficiaries the moment you pass or the moment you're in incapacity to those beneficiaries when they need it most. Because if you pass and your beneficiaries are just sitting there waiting for the court to decide as to whether they're going to have guardians or whether they're going to have funds, that's the last place you want to be. You want title to those assets to pass immediately. And you keep assets in a trust. So again, I like people to think, a lot of people have this, they don't really know what to think of what a trust is. And so what I like to say is it's another person. It's a living person that exists there. You created it. You fund it with an insurance product or cash or securities or a home or whatever it may be. And you keep it in trust. So it's a little bit jarring when I say this, but the best clients I have nothing. Let me say that again. The best clients that I have literally have nothing to their name because they've transferred everything to the trust. They've transferred everything to the trust, so they transfer everything to a series of corporations and entities so that their wishes at the time of their death or at the time of their incapacity are fulfilled by the trustee and money gets to the beneficiary as quickly as possible. And finally, we want to prevent unintentional disinheriting. This is something that occurs sometimes, especially in the court proceeding, but it shouldn't be an issue at all. And this is another issue that's become less and less of an issue as the estate tax has risen, and now it's up to, I believe, a little bit over 11 million a person. But the estate tax can be a concern if you're in that category, and in the event it's not properly planned for, you can lose up to 40 and 50% of your overall value of your trust. So this is a fun picture to say that we are done with our first set of slides associated, and we are going to move on to our second set of slides, which deals specifically with special needs planning. So let's talk quickly about comprehensive estate planning for individuals with special needs. This is something that our firm has always felt honored to be involved in. And traditional estate planning is a very fulfilling profession and something that we take great pride in. But when you're talking about being an attorney for an individual who feels so much stress and feels so much anxiety and really is trying to just do everything themselves because they're just trying to get to their goals, we're able to step in and provide a moment of possible clarity, provide a moment of possible hope, and again say that we're part of your team. We're here to help you, and we can be a sounding board for everything. And when you're the estate planning attorney for an individual with special needs, you become a part of that person's inner circle, not just during the time you're in here in our meeting, but really for the rest of the individual life. So that all goes to say that my first slide says people love their estate planning attorney, which is a great pat on the back here. So there's going to be some overlap, and we created these slides so that people could, again, take them home, look at them, read over them again. And this first slide goes to directly what I was talking about in terms of estate planning trust. So again, you control your property while you're alive, and after your death. So with proper special needs trust planning, you are allocating during that individual life, in your life after you're gone. You're planning for yourself and your loved ones if you become incapacitated. So your life doesn't exactly end, or life doesn't end around you in the event you fall into a coma or get into an accident or whatever it may be, and you're incapacitated. By which the trust enables your wishes to be carried out after that incapacitation. So we want you to be able to give what you have to whom you want, how you want, when you want, and that kind of goes for all of proper estate planning. You're putting down on paper your wishes so that somebody else can follow them. So these are the four areas that need attention: your property, your family, yourself, and your legacy. So when we look at dividing up the various estate planning assets, we always look at these four categories. So we look at your property because usually that's the biggest thing in folder. Excuse me. And we are able to estate plan for that. your family, which includes your children, and your legacy. Of course, after you pass, you want to set out goals that can be attained and can be furthered by your trustee to most benefit your beneficiaries. So again, this goes into the fundamentals of a comprehensive estate plan. So what we're dealing with here is I'm really talking about elements that I look at. I look at the fact that planning must be coordinated, and that goes right into members of the team. So in a second, it's exactly what Lamar said, which was there really are 3 tiers to the team. There's the financial advisor, the individual who's looking out for your finances during your life and after your life, and that individual works directly with the estate planning attorney. I can't tell you how many times I've established great relationships with financial advisors for the mutual benefit of the client. And the more that we can coordinate together, the better an estate plan, the better the life of the client will be. We also have to bring in the CPA because taxes are an inevitability. So taxes always become an issue when you're transferring ownership in properties, when you're transferring ownership in securities or any kind of asset, as well as after your death. Because you set up a trust, your money is going to grow and you're going to continue to have wealth. So a CPA is absolutely necessary in order to comply with all the regulations of the IRS. So this is my fun diagram of all of the commingling between all of the individuals, the financial advisor, the accountant, the estate planning attorney. I can't stress enough how much it is necessary to have these individuals talking with one another. My firm actually went so far as to incorporate a tax planning section of our firm. So we actually absorbed 4 different accounting practices into our law firm in order to better aid our client in this space. A financial advisor, I know Lamar, so I don't need another financial advisor. So it's
I like the sound of that.
That's it. What's that?
I like the sound of that. We're a great team. We represent a number of people together. Yeah,
exactly. So I mean, and as Lamar will state, it's of great benefit. You know, anytime a financial advisor is looking to further the financial interests of an individual and increase the valuation of their portfolio, it inherently deals in issues that an attorney must deal with. So if there's a communication, open line of communication amongst all those people, so much stress can be we can absorb a lot of the stress, so you don't have to deal with it. Okay, so this is something I like to put this right here, just simply to reassert that what we're trying to do is protect and provide for your spouse and children and avoid family conflict. Now, one of the issues, if we have 10 families on this line or 10 individuals that are listening to this recording, what I'll say is it's almost a guarantee that each and every one of you can think for 2 seconds about someone in your family and say, oh yeah, that person might make some trouble. Well, one of the ways in order to alleviate that sentiment is to establish an adequate estate plan, a great estate plan. And the reason is because when you have a proper estate plan, the issue of where things go, who the beneficiaries are, who the trustees are, and who will get what, where, and why is already dealt with. So there's no conflict. But if you're going to court and you're dealing with wills and you're dealing with lawyers and you're dealing with guardians and this and that and the other, there's plenty of time for that individual or that family or that whoever it may be to come in and argue and postpone money, assets, and care that is necessary for the individual beneficiary, special needs or not. So we're planning ahead. One of the things we always want to do is provide for the special needs individual. Make sure they're getting the benefits that they need to be getting. Make sure they're qualifying for the benefits that they need to be getting. Make sure that we're not doing anything or structuring anything that will prevent them from getting something that they have a right to and they have a need for. And of course, I always like to put in there, leave a lasting legacy. You know, if you pass, unfortunately, and you're left in a situation where people still are dependent upon you, we want to leave a lasting legacy of competence, leave a lasting legacy of planning, and that's something that is easy to facilitate if one just takes the chance and establishes a solid estate plan. So again, I go over this again because I can't tell you how many times somebody's come into my office and said, "Oh, I've got a will, I'm good." So a will is a document that is that's only purpose is to provide a directive to the court. So judge reads it like a note. You give it to the judge. The judge says, "Oh, fantastic! This is the way that Dan wanted to give away his property." But the time, energy, and expense necessary to get there, it's a lot. And so we want to bypass any influence that the court may have. This is a slide that I'm going to kind of just run through. It's something that I harp on and on about wills and how we need to supplement a will with a solid estate plan. And as you're going through this in your own time, this will further enforce what a will is and how it needs to be supplemented. So a trust here, and we're gonna move right into the special needs trust section of this. So again, a trust is a private agreement between a grantor, who is the individual who comes into my office and talks to me, and a trustee, who is that individual for the time being, for the benefit of the beneficiary. So as I said previously, the grantor, the trustee, and the beneficiary can all be the same person at the outset of the trust. Usually are. So if you have a revocable living trust, you're the grantor, so you're giving the property to this new person that is the trust. You're the trustee, meaning you're the puppet master for this trust, and you're the beneficiary. So during the time that you have this trust, you will be the beneficiary of the trust. Now we're going to be talking about third-party trusts and self-settled trusts, all of which are inherent in special needs trust planning, where the beneficiary can be a different person. We have non-grantor trusts that are also inherent in some special needs trust planning. So this goes through something that you can you can read after this recording as well. It can be established for yourself, can be established for somebody else. One of the biggest objectives is planning for future expenses, future medical. Trusts, individual trusts, can be set up for a specific goal. So you can say, okay, well, in the event there's an incapacity at the age of 25, I want to set out a certain amount of money for that event, or I want to set out a certain amount of money for education in this way at this time. And regardless of whether during that time you pass or not, those objectives are going to be fulfilled because you have a trust. So let's get right into special needs trusts. And I've touched on this a little bit previously, but our goals when we are creating a special needs trust and planning for special needs individuals or special needs families is we want to always be mindful and protect eligibility for government benefits. There are a tremendous number of government benefits that are out there for special needs children, special needs families, and we want to always be mindful of those government benefits, be able to take advantage of those government benefits, but also to be able to pass on wealth, pass on benefits to the individual that provides for a higher quality of life. And that's my second point right there. So we want to provide for a framework of care and management of the assets, even though we're protecting eligibility for government benefits. That should not have anything to do with our wishes when it comes to the care and management of the assets. So allow the parents to express their desires. Each child is an individual. Each child is different. And so each parent will have their ways in which they want their child parented and provided for, and how they want their child to be the beneficiary of what, when, and how. So a trust is a very individual document. I can't tell you, I mean, every single client that comes in here, there's nothing that you can just take off the shelf and use. Each individual is completely different. And again, we're talking about protecting our assets from creditors and predators. You know, one of the things that we always are dealing with, or sometimes seeing, is clients who come in and say, you know, they've levied my accounts, they've done this, you know, there are people that are out there trying to take advantage of me. Proper estate planning can alleviate this concern. And of course, extending the life of your assets. If assets aren't given away in probate, well, then they're in a trust and they can extend the life. So this kind of goes over some of the mistakes that you're going to see that people make when planning for their child with special needs. So again, I go over this. There are some attorneys that would, I don't think it's as readily used as it was in the past, but their plans were to disinherit the child, or relying on other children to provide for the child with special needs, failing to provide for the child with special, provide privacy for the child with special needs. One of the most unfortunate things we see is that there are what I would call predators who prey on estates that are being passed on publicly to individuals with special needs, and they prey on those individuals in order to usurp the wealth associated with, or any money associated with, the estate. This is something that, in the event an individual has a proper estate plan, would never become an issue because it'd be private. And of course, choosing the wrong professionals. So we're the right professionals. You're not going to choose the wrong professionals. We're going to make sure of that. But you know, you need to have an interpersonal relationship with your professionals, and have a group of professionals that you know, will tell you, you know, you're now part of a family. This is HDC, and Lamar's group is not just independent. We work together. We achieve goals together. So there are three kinds of special needs trusts, and I'm going to give an overview of these, and because each person is different, each family is different, I'm going to give a bit of an overview, and there's a lot of depth to, not surprisingly, I'm sure you can assume, there's a lot of depth to each one of these categories. So in terms of the special needs trust, you have a self-settled SNT, a special needs trust, a third-party SNT, and what's called a pooled SNT, which I'm not going to touch on very much, which may be something good to touch on in a later recording. But I'm mainly going to focus on a self-settled SNT and a third-party SNT. So let's go over the self-settled is a tongue twister, self-settled special needs trust. So it's established with the beneficiary's own funds. You know, normally when you see a self-settled special needs trust, it is the result of a lawsuit, possibly a medical malpractice or personal injury lawsuit, where there's a huge windfall to the client, or a windfall of any kind. And that's what I say in my set. Most commonly funded by proceeds from a lawsuit or inheritance payable directly to the disabled beneficiary. So one of the issues that always comes up is the difference between a self-settled special needs trust and a third-party special needs trust. This next provision is probably the biggest difference between the two. One requires a payback of anything that was state-sponsored, essentially anything that was paid by Medicaid. It has to be paid for the beneficiary. So the trust includes provisions directing trustee to pay back anything to the state. Medicaid program is paid for the beneficiary. Not that this is a bad thing, but it allows for you to accumulate wealth via a variety of instances during the individual's life, and then at the time of the passing, then the Medicaid program is paid back. A lot of times this trust is referred to as a D4A trust. So it is, you know, it can be called either one. A lot of times people don't want to use the tongue twister, self-settled special needs trust. They just say it's a for a trust. And then there's a lot of ways to say this: first party trust, payback special needs trust, or litigation special needs trust. What will happen, the practical course of things is, in the event it is a result of a lawsuit, the lawsuit proceeds will actually, the beneficiary lawsuit proceeds will be the trust directly. So there's no interference with or infringement upon any existing governmental benefits. Established by the parents. So if we have any individuals listening to this who is a grandparent who thinks, oh my God, well, I wish it could be. No, it can be established by a grandparent, even though the disabled person is the grantor. If there is a lawsuit that is the result of these proceeds, that lawsuit attributes those dollars to the grantor, or the individual who is now in a state of special needs, or an individual who needs it. However, the trust in and of itself can be the beneficiary of those dollars and set up by the parent, grandparent, or other. So one thing that I'll go over again is that there has to be a repayment at death of the beneficiary. There's a sole benefit requirement, which is to say that it has to be solely for the benefit of the individual. It must be irrevocable. The new laws that have come into effect do not entirely make this a black and white issue. These can be irrevocable in some senses, but normally are irrevocable in nature. So the beneficiary in this case cannot be the trustee. So whereas in a revocable trust, you can be the grantor, the trustee, and the beneficiary, this is literally a trust that is set up by somebody else for the benefit of the grantor, for the benefit of the individual who has special needs, for their benefit during their life, for their sole benefit during their life. And at the time of their death, there is a repayment. So I'm going to go over third-party special needs trust now. So this is established by someone other than the person with disabilities or individuals with special needs, with assets never belonging to the beneficiary. So a lot of times what we see is a grandmother, a grandfather, a friend, an uncle, you can name the various relatives who would like to establish trust to pass down inheritance to an individual. The biggest benefit of this is there is no payback requirement provision for Medicaid upon the individual's death. So inheritances can be had during the individual's life without a payback to Medicaid. This is why third-party special needs trusts are so popular and become a great advocate for individuals with special needs and special needs children. So during the beneficiary's life, kinds of payments the trust can make will be more generous and more flexible. It's a pretty flexible instrument, so it's something that can be utilized during the life of the individual with special needs, in order to make their life easier and allocate for things that they want to further. And again, could be created during lifetime or at death. You could establish a third-party special needs trust at the time of an individual's death. So in your trust, you could say, when I die, establish a third-party special needs trust for Tim. Tim has special needs. He will then have a third-party special needs trust specific to his needs during his life. It can be established by will. I don't recommend it, because then you go through the court proceedings. But it can be established by will. It's a heck of a lot better if it's established by a trust. Now, if I'm going back here we go. So it can be established if established inter vivos. So established inter vivos means established during one's life via usually a trust instrument. So if you're establishing this via trust instrument, where which I would recommend is the best policy, it's effective immediately. The trustees and successors get training and experience as to how to establish and to provide for the individual with special needs. It can be the beneficiary of life insurance. So essentially, a third-party special needs trust can be the receptacle for a life insurance product, which also funds the trust at an individual's death or during a person's life, depending on the type of insurance. This is the most popular way in which it is utilized for grandparents. So grandparents want to leave a sizable sum or any kind of sum to a grandchild with special needs, but a lot of times their fear is that doing so may disqualify them for benefits. Well, this is a great way to do that. Third-party special needs trust is put in place so that inheritance can pass, and it doesn't disqualify you for benefits. So I know that was kind of a grand overview of the various kinds of special needs trusts. I will say that in all, the number of special needs trusts that exist in their variations is somewhere around 20 to 25. And I say that in order to provide, again, hope to everybody out there who's listening, to say, listen, regardless of what your situation is, regardless of what the stresses are, I will say that many times we may not have the perfect solution, but we can walk you through what a solution may be, and we can shoulder a lot of these stresses together. So how do you choose a trustee? Now, obviously, if you're the trustee, then you chose wisely. But if you need to choose a successor trustee, that becomes more of an issue. So initially, you choose you or your spouse. Next, you have to choose who is going to care for your child and who is willing to be able to devote the time and energy necessary to caring for your child, caring for finances, caring for property, all this type of thing. And have serious conversations with these individuals. This is not something I like people to come in and just say, oh yeah, Jim and Nancy, they'll take care of it, no problem. No. Sit down with Jim and Nancy over a glass of wine, talk to them, and have them understand and conceptualize and think about how much time they will need to devote, how much energy they will need to devote if they have the ability to manage the assets properly and care for your child in the way that in the way that you would in the event you could. And obviously they're going to have to be willing to learn. The trustee, this is not something most people just off the street who may be your friend. These are not individuals who immediately know how to be a trustee. But that's, again, where the proper team comes in to teach them how to manage the assets. Basically, I guess the lesson in all of this is nobody is alone. I can't tell you how many times one of my clients has had a relative or they themselves pass, and their relatives come to me, are broken, are sad, are in a state of disrepair, are nervous, or stressed, whatever it may be. And my entire job at that point, that's really when my job kicks in. My entire job at that point is to say, everything's going to be okay. A plan was put in place for this. I'm going to teach you how to be the proper trustee. And when you have any problems or any questions, you call me. It's as easy as that. And we're able to alleviate some stress. And along with Lamar and his planning in combination with what we do, we're able to alleviate a hell of a lot of stress that people go through, and are really be able to establish a family that helps people along and willing to seek advice. You have to be able to say, listen, I don't know what the heck I'm doing. You want somebody who has that sentiment, who is able to say, you know what, I need some help here. I'm going to use some of the assets, or I'm going to use something to go seek the advice necessary. And obviously someone that you trust. I mean, that kind of goes without saying. That's inherent in trustee. So here's what I'll say about professional trustees, and I'm sure everybody's heard about the various trust companies that are out there. A lot of the first reactions when people do have a large inheritance to provide to their beneficiaries, or if there's a large cash settlement, maybe a medical malpractice settlement or a personal injury settlement or any kind of settlement, and there are millions of dollars in play, their first reaction is, oh, I'm going to go have a professional trustee. As many great stories as I've heard equally as many horrible stories. And the biggest issue that I find is they are not attached to your child. They are a corporation at the end of the day. And from a black and white objective standpoint, they do a fabulous job. But when it comes to taking a subjective view or a emotional view of what might be necessary, that is where they falter. And so I am not a proponent of professional trustees. I've worked very, very closely with professional trustees over the years. I've had good relationships with them and poor relationships with them. What I'll say is if I had my druthers, I would pick someone who is close to you from a family perspective and then build a great team around that person. So I'm just going down here giving you reason why you shouldn't do it. They're bonded and insured, which is of course a plus. But in order to care about that, they have to screw up. So essentially, if they're bonded and insured, that's only good if they're not doing their job. They're more likely to properly manage the trust, yes, and provide excellent record keeping, yes. But those are what I would consider objective tests. And as long as during your life you are able to provide for the proper team, the team can do that as well. Charge for their services. Trustees are not cheap. While I say all trustees should be compensated, and I absolutely agree with that, professional trustees charge for their services. So it can become very, very cost prohibitive. So I want to talk briefly about guardianship in Illinois, and I apologize, this is going a little bit long. I like to spend a little bit of time and talk about these thoroughly. So we're going to talk a little bit about guardianship in Illinois, and this kind of goes for a lot of states. Any interested person can apply to a probate court for guardianship of a person or property. That is true. So when there's a guardianship hearing, any interested person can apply. So that person that I had you think about earlier who would cause trouble in the event there was a family issue, yeah, that person can become an interested person and can apply within the probate court to become a guardian of your person and property within the courts. That's why we want to greatly avoid that. So the court will appoint an attorney for the proposed ward, and an independent evaluation will be conducted, and the court will look to any advanced guardianship designation. So they're going to look, the court will take into consideration, and I want you to understand that, take into consideration, but that is not a finality. They'll take into consideration any guardianship designation. So if you say within your will, listen, I'd really like Timmy to go to Janice, well, they'll take that into consideration, but they're not automatically going to do it. And an independent evaluation, which is going to cost money, and an attorney is going to cost money, and the guardian's going to cost money, the court's going to cost money. The court will appoint an attorney for the proposed ward. So an attorney that you've never met before will essentially become the eyes and ears for your child and your beneficiary, and determine how the rest of his or her life is going to be. So how do I designate a guardian? So a lot of times this goes hand in hand with a trustee. Sometimes it does, sometimes it doesn't. Sometimes an individual approaches some of their friends and says, listen, I'd really like you to become the trustee and guardian. But the individual says, listen, I have no problem looking over your property, but when it comes to being a guardian for your children, I'm just not prepared for that. And that's fine. You need to. The one thing that I say to clients is respect that decision. And if you're designating a guardian unattached from the trustee, here are some of the things you probably want to look for. So a guardianship designation can be done by will for minor children or by trust. I obviously prefer trust. In the sense of a will, it's only an expression of your desire. Court is the only entity that can appoint a guardian over someone else in that case. Natural or adoptive parents are presumptive guardians over minor children, even in the event of a divorce, unless other court specifies differently. So there are presumptive guardians, but I will say I have seen instances where somebody just shows up and that's, the de facto guardian until someone else comes up. It's kind of it's a very strange process to it. We're going quickly to what a durable power of attorney is, and these are a lot of times kind of skipped over, but they are something that I definitely do not want to skip over because they most readily become issues during times of incapacity. So an individual's agent is an individual's agent during a time of incapacity is very frequently their trustee. So it allows your agent to act on your behalf when you're unavailable or incapacitated, and can either be springing or immediate. So springing requires usually 2 licensed physicians to give proof of the condition that you have that requires incapacity. Immediate leaves the door open for allowing agents to act on your behalf immediately. Now, I put this little red mark down at the bottom that says no guarantee that financial institutions will accept the DPOA. Sometimes we have to alter DPOAs in order to comply with some of the financial institutions, but that's something that's why you have an attorney in order to do this kind of stuff. So healthcare power of attorneys, So healthcare power of attorneys, these are individuals that are put in place to make healthcare decisions for you. This is kind of the proverbial individual to pull the plug. I don't know if everybody saw the Seinfeld episode where Elaine becomes Kramer's durable power of attorney for healthcare. But that's always kind of what I think when I think of healthcare decisions. So you're incapacitated. This avoids the need for guardianship because you're appointing individuals via your healthcare power of attorney to look over your beneficiaries and look over your children during the time of incapacity. So they have a duty to make the decision that you want to make. So you aren't there mentally, physically, possibly, but you're able to still effectuate your wishes and decisions even though you're not there. A living will very, very closely resembles a durable power of attorney for healthcare. So it's an expression of your desires regarding life-sustaining treatment. So think of, God forbid anybody gets in an accident, they are put into the hospital. There is the question as to whether to allow them to live immediately or to provide immediate care. That would be covered under a healthcare durable power of attorney or a healthcare power of attorney, whereas life-sustaining treatment when death is imminent is usually dealt with in a living will capacity. So hydration and nutrition, hydration not nutrition, these are different decisions that you can make as an individual to sustain life and sustain various activities when death possibly could be imminent. And of course, I always get back to an individual's legacy. How do you want to provide for your legacy after you have passed or while you're in a state of incapacity? At that time, when an individual passes, when a client of mine passes, or when somebody finds themselves in a state of incapacity, the individuals around them are in a state of flux and in a state of incredible stress. And so providing for your legacy in terms of establishing a solid estate plan will relieve at least a portion of that stress, and will put in place a great team that will be able to further alleviate the stress from individuals who at that time need the help the most. So what do I need at a minimum? So yes, you need a will, and we'll go over in person. I'll talk about more of what a pour over will is. Essentially, when you have a trust, you always need a will in order to just pour over everything else. But a will just standing on its own is not recommended. A special needs trust, we just talked about various kinds of special needs trusts. These are things that these are instruments that are specifically designed to keep in mind governmental benefits and the passage of wealth, passage of property in order to best be allocated for that individual with special needs. A durable power of attorney, we talked a little bit about that. A durable power of attorney for healthcare and a living will. So I'm hopeful that everybody's not asleep and I'm not waking everybody up right now, but this is my information. And I hope that, in short, we were able to give you kind of a very preliminary overview and inform everybody a little bit about the estate planning process, what the benefits of some of the estate planning techniques are, and more than anything, hope that there are solutions out there to alleviate stress, and the confidence that between Lamar and myself, we are ready, willing, and able to become a part of your family structure and team for the future. So that's all I got. Lamar?
Well, thanks for taking the time to actually really dig into some great detail for a lot of the families. What we're going to do now is I'm just going to switch it back over, and what we'd like to do is just hear from the families who do have the opportunity to watch us and just give us your feedback. We want to make sure that these conversations, obviously in the beginning, there's a little bit more information that we'd like to share. What we'd like to do is make sure that the information that we're sharing with you is meaningful to you and that you are getting something from that. So what we'd like to do is just kind of give a little survey towards the end and allow for us to hear from your feedback. You can reach out to myself or as well to Katie Monbush, who has copies of the survey as well, just so we can hear from you. We'd love to hear your feedback. We think that these conversations are going to be beneficial, and as we go, we will have some more targeted focuses and some case studies and things like that to really continue to push forward the educational purpose of why Nancy thought these were great conversations to implement into the programming for GiGi's Playhouse. So everybody have a great rest of your evening. We look forward to hearing from you. The Midwest Legacy Group, myself, Lamar B. Butler, please feel free to incorporate us. Myself and Jonathan are happy to sit down with you collectively and be able to be a part of that conversation that I mentioned. So we look forward to hearing from you all very soon. Have a great night.
Thank you.